All right, I'm Jason Causey, and I will be brief, as I've been warned by Mr. Marshall. um, so, my topic is a rising problem, and I call it the double taxation of attorney fees. Now, the topic may be directed mostly at plaintiffs practitioners, but for you industry folks, trust me, there's a part for you to play in it, and I'll get to it at the end. The problem is that attorney fees paid in consumer credit protection cases are being considered widely as income to the client. And the big exception to that is physical injury cases, personal injury cases, where you've got some type of personal injury, because none of that income, all of that income in those cases is exempt. But short of a personal injury case, any plaintiff practitioner needs to be aware of and consider the tax consequences to their clients. And let me give you an example of a first-party bad faith case that I'm painfully aware of. There was a case litigated last year, and it was you had a car wreck case for the first part of it that was settled, and then you had a following bad faith insurance case for claims mishandling and so forth. Different torts, and it was settled after several years of litigation. Settlement was fairly large, between $500,000 and $1 million, and because the case took so long, it was expensive. There were several depositions, there were experts, attorney travel all over the country, so forth. There was 6 figures in costs, out-of-pocket costs for the attorneys, plus their standard contingent fee arrangement. So the client, gets the advice of the counsel, and as soon as they get their money, and they go to their CPA, and it says, how much do we have to hold back for taxes? They're getting ready, they want to buy their new house or buy whatever they're going to buy, and the CPA does the calculation, and he says, all of it. Not only all of it, you need to reach into your pocket and come up with another $30,000. And so that is because of, and that's an extreme example, that's not your normal problem, but there is generally a problem throughout these cases with the double taxation of attorney fees. And the reason for that starts with the seminal case of Commissioner versus Banks. That's a U.S. Supreme Court case from around 2004. It was an employment discrimination case where the plaintiff brought an employment case under a normal, typical contingent fee contract. There's a settlement. Plaintiff recognizes in their tax return all the money they received, the net proceeds from the settlement, does not recognize the attorney fee portion in their tax return. IRS performs an audit, has a problem with that. The IRS wins at the tax court level. The consumer or the taxpayer ultimately wins at the Court of Appeals, and then the Supreme Court takes it up. The Supreme Court says that the amount paid to the attorneys under the anticipatory assignment doctrine, and because the client continued to control the asset, that being the underlying claim, had to recognize that income. And that has been the law and a problem ever since for a variety of cases. Now, Congress tried to remedy that for employment discrimination cases with the American Jobs Act, and I'll get to that briefly. But rest assured, outside of specific, narrow examples, this is an emerging problem, and a problem that has gotten worse in the last couple of years. Banks there is a crack in banks, and that's what I want to come back to at the end and really throw out there as a potential solution. The crack in banks is that the court specifically said that there was no court-ordered fee award, nor was there any indication in Banks' contract with his attorney or in the settlement agreement with the defendant that the contingent fee paid to Banks' attorney was in lieu of statutory fees Banks might otherwise have been entitled to recover. So what the court ultimately did is punt on the issue of whether the public policy behind a fee-shifting claim could alter this dynamic of who needs to recognize the income and when. Again, we're going to come back to this. I want to cover the more recognized examples before I dig into Banks anymore. So Under banks, we've covered that the amounts paid to the attorneys in these contingent fee contracts in the plaintiff's proceeding is income to the consumer or the plaintiff generally. Then the question becomes, can you deduct what you pay? You should be able to deduct it, surely, right? You don't get to keep the money. You should surely be able to deduct it off the income you earned. Well, there's two types of deductions. There's an above the line deduction and a below the line deduction. The above the line deduction is certainly the more valuable because it's a dollar for dollar reduction in the tax liability. The attorney fees that qualify for the above the line deduction are as follows. Under the Jobs Act that I talked about, employment discrimination cases, certain other employment cases, the Congress has passed a law that will allow you to deduct the attorney fees incurred in those cases above the line. Civil rights cases have a similar exception, and they allow for a deduction. And then attorney fees earned, or attorney fees paid in the course of any trade or business. So, of course, small businesses, corporations, they can deduct their attorney fees that they incur in the normal course of business. But individuals, not so much. The individuals typically had to rely on the below the line deduction, which was subject to complex rules such as the alternative minimum tax rule, the 2% AGI rule. But nonetheless, there's some deduction, there's some hope. Well, there was. There was until the tax legislation, unintended consequences, as Mark talked about. They eliminated all miscellaneous deductions. So no longer are attorney fees deductible in any way outside of their specific exemptions, because there are no longer any miscellaneous deductions, at least until 2026, when Trump's tax break expires. Now, the more recognized exceptions, we talked about one already. If the damages are exempt, the attorney fees are, of course, not taxable either. Those are personal injury cases primarily. Consumer practitioners shouldn't be so quick to dismiss this exemption. I had a case a few years ago. It was a wrongful foreclosure case, and it was a big case. It involved it was a fairly large settlement, and there was towards the end of the case, we're getting ready either to settle it or try it. I started thinking about the tax liability in the case, and it occurs to me, wait a minute, my client was wrongfully foreclosed. She was evicted. She was handcuffed and taken to the police station. She had bruising on her arms. She had a physical injury. She had bruising on her arms. I amend the complaint, alleged personal injury claim, and the defendant agrees not to issue a 1099 as a result. So don't be too quick to dismiss that exemption. Every once in a while, you can find a physical injury case in a consumer case. Certain civil rights cases, sometimes involving counterclaims, you can fit a consumer case and add a civil rights claim. Not very often, but it can be done occasionally. Class actions are generally not a problem, but it's sort of beyond the scope of this presentation. But generally, class actions do not create a problem for attorney fee taxation. This is a big one at the end for Mountain State Justice and its clients. Legal fees paid to pro bono legal service firms, typically under an IRS letter ruling, the clients don't need to recognize the income. So consider maybe joining forces with Mountain State Justice in some cases. I certainly do. And so now, those are really the recognized exceptions, and they're fairly narrow. Everything else in a consumer case, you've got to worry about this double taxation, which returns to the crack in banks. The tax initiative by the National Association of Consumer Advocates and some other consumer advocate groups petitioned the IRS and asked for a letter ruling. And the letter ruling was to see how far they could take the dicta from the bank's case. And essentially they said, well, if the consumer, not at the end, but at the very beginning of the case, assigns their statutory right to fees, not anywhere, not any common law right or contract right, the statutory right to fees, to the attorney, that then becomes the property of the attorney, and the attorney settles that case along with his client's case, and therefore that amount of the amount attributed to the attorney fees shouldn't go to the client. It's been assigned, it's owned by the lawyer, and it's got the backing of the public policy behind the fee shifting, which is that the defendants should pay for the plaintiff's fee, because these are the types of cases that wouldn't be brought without these fee shifting provisions. You know, someone buys a refrigerator that doesn't work in 6 months, that costs $800, they're not going to find a lawyer to represent them. The only way that a lawyer will take a warranty case like that is if there's a fee shifting provision. And in that case, if I've got a fight with the store, the retailer, or the manufacturer, the fees may be $50,000 by the time we go to court and we get the end of it, and the damages are $800. Can you imagine the bill to the consumer? And this problem, and that's why when the Supreme Court heard those types of arguments, it didn't dismiss them out of hand. So the assignment issue and the possibility of the statutory fee, it seems to be the only real resolution for the consumer. Now here's where the industry comes in. The IRS has a matching program, right? If your 1099s don't match the reported income, you get audited, generally. And so some of the industry folks, depending on who the player is, doesn't have a problem with how they issue the 1099. If the check is written to just my firm and then I distribute the money, they'll get their language in the release that says, you know, we don't provide tax advice, you're responsible for all the taxes, but they don't issue the 1099, they just issue it to my firm and move on. Or alternatively, those who insist on issuing some type of 1099 to the client, to the consumer, you know, I ask them to write 2 checks. I'll say, write a check to me for my fees, issue me a 1099, issue Borders and Borders a 1099, and then issue the client a 1099 for their piece. We'll spell it out in the agreement. A lot of people don't have a problem with that. But what I've seen is, particularly some of the larger national banks and other industry players, some of them are just insisting on issuing a 1099 no matter how they issue that check to the consumer for the full amount. And that creates the problem. Then at the end of the day, every January to April, if I permit that as a plaintiff's lawyer to happen in part of the settlement, I'm getting calls from my clients. I've got to find them tax representation or help them do something, because they now have a significant problem. They have far less money than they thought, because they have to pay taxes on our cost and our fees. So if we have a chance to ask questions, I'd ask questions of the industry instead of ask questions of me, because I want to know why these 1099s are being issued that way. But I do appreciate the time to come up here and just pose this problem. I know that it's a problem that some of us who've done plaintiff's work have thought about for a long time, but some of us are just becoming aware of it. So thank you.